I have heard the Constitution quoted in my courtroom more times than I can count. Most of the time, it is done correctly. Sometimes it is misunderstood. And occasionally, it is used like a magic spell people believe can erase responsibility. But I will never forget the day Karen Blake stood in my courtroom, raised her voice, and cited the Constitution as if it gave her immunity from reality itself. That case still circulates online for a reason. Because what happened next was not just a legal correction. It was a complete dismantling of a carefully constructed illusion. Her name was Karen Blake. And from the moment she stepped inside, I could tell she had already decided the outcome. Those are the most difficult cases, not because they are complex, but because someone has already replaced facts with certainty. Karen walked in wearing a sharp navy blazer, holding a thick stack of printed pages, all highlighted in different colors. She didn't look nervous. She looked prepared, hearing for information. Across from her stood Thomas Reed, a freelance contractor in his early 40s. Quiet, tired. Careful, the kind of man who works job to job, relying on reputation more than anything else. His claim was simple. He said he completed a home renovation project for Karen, including kitchen upgrades, flooring installation, and exterior repairs. He said she approved the work at every stage and then refused to pay the final balance once the project was finished. Karen's response was immediate. She claimed the work was incomplete, overpriced, and financially deceptive. But what caught my attention was not the dispute itself. It was how she prepared. She didn't bring just evidence. She brought ideology. Before I even opened the file, Karen stood up. "Your Honor," she said, "before we proceed, I need to establish that my constitutional rights are being violated in this courtroom." The room shifted slightly. Thomas looked confused. I asked calmly, "Which constitutional right do you believe is being violated?" Karen lifted her stack of papers. "All of them," she said. That answer told me everything I needed to know, because in law, specificity matters. All of them is not an argument. It is a performance. I leaned back slightly. "Mrs. Blake, this is a civil contract dispute regarding unpaid work. Please continue with relevant facts." She shook her head. "No. The Constitution overrides this entire proceeding." A murmur moved through the gallery, not agreement, confusion. I noticed Thomas exhale slowly, like a man realizing this was going to take longer than he expected. Karen continued, "I have the right to due process, fair treatment, and protection from financial coercion." I nodded. "You do?" She smiled, as if she had won something. "And I am being denied those rights." I looked at her carefully. "Based on what specific action?" She raised her voice slightly. "Based on this entire system." That was the first red flag. Because when someone stops pointing to facts and starts attacking the entire system, they are usually trying to avoid a specific detail they don't want examined. Thomas then submitted his contract, signed, dated, dishealed at every stage. Karen glanced at it and immediately said, "That document is irrelevant under constitutional law." The courtroom went quiet again. I remember thinking something very simple at that moment. This was not going to be about construction. It was going to be about control, and Karen believed the Constitution was her tool to take it. What she did not realize was that she was about to learn how quickly that strategy collapses when evidence enters the room. Thomas Reed placed his contract on the table without hesitation. No drama, no speeches, just paper, signatures, and dates. The kind of evidence that doesn't need interpretation to exist. Karen Blake didn't even look at it properly. She waved her hand slightly, as if she could dismiss physical documentation the way someone dismisses a bad suggestion. "That contract is invalid under constitutional protections," she said. I paused for a moment, not because I was uncertain, but because I wanted her to hear the weight of what she was saying. "Mrs. Blake," I replied, "the Constitution does not invalidate private contracts voluntarily entered into by competent adults." That sentence should have brought clarity. Instead, it triggered escalation. Karen turned to the gallery as if she were addressing an audience, not a courtroom. "I am being financially exploited," she announced. Thomas remained seated, still, tired, watching. That contrast mattered. People who are telling the truth often don't need to perform it. I asked Thomas to explain the work again. He spoke clearly. He described the kitchen demolition, the replacement cabinetry, the flooring installation, and the exterior wall repair after storm damage. Each stage had approval messages from Karen herself. He submitted screenshots, text messages, photos of progress. Karen finally reacted, not to the content, but to the existence of proof. That's taken out of context, she said immediately. Then she added, and I revoke consent to all of those communications being used. I looked at her. Consent cannot be revoked retroactively for evidence already created. That line landed quietly in the room, but it mattered because it revealed something important. Karen was not disputing facts. She was attempting to rewrite the rules around them. Then she reached into her folder and pulled out her printed pages again, this time more aggressively. She began reading aloud. The Fourth Amendment protects me from unlawful financial targeting. There was a pause in the courtroom. A very specific kind of pause, the kind that happens when people realize someone is confidently saying something that is not real. Thomas lowered his head slightly, not in defeat, in disbelief. I asked gently, Mrs. Blake, which legal source states that the Fourth Amendment applies to payment disputes? She responded instantly. It applies to all government actions. That answer was wrong, but more importantly, was absolute. And absolutes are dangerous in court, because they leave no room for correction, only confrontation. Thomas's attorney then submitted the final invoice. The remaining balance was clearly listed, along with signed acceptance of the completed work. Karen glanced at it and said, that invoice is fabricated. I asked, do you have evidence of fabrication? She raised her voice. The Constitution is my evidence. And in that moment, A.B. realized this case was no longer about misunderstanding law. It was about using the language of law to avoid accountability entirely. Karen believed if she said Constitution often enough, it would replace everything else in the room. But courts do not operate on repetition. They operate on verification. And verification was about to arrive. Verification arrived in the form of something Karen Blake clearly did not expect. Bank records. Thomas Reed's attorney placed them on the table without ceremony. Just stapled documents showing partial payments made throughout the project. Deposits that matched each stage of completion. Notes referencing kitchen phase, flooring milestone, and final exterior work. Karen leaned forward slightly. Not to study them, to resist them. I've seen that reaction before. When someone realizes the evidence is not going to bend, they try to bend the perception of it instead. This is irrelevant, she said quickly. I looked at her. Payment records are directly relevant to a payment dispute. She shook her head. You're interpreting the law incorrectly. The confidence was still there, but it was starting to thin at the edges. Thomas remained silent. That silence was important because honest litigants often stop speaking when they realize the truth is finally speaking for them. Karen, however, spoke more, not less. That is another pattern I've observed over the years. When reality tightens, some people become quieter, others become louder. Karen fell into the second category. She stood again. This entire proceeding is unconstitutional, she declared. Then she pointed at Thomas. He is attempting to use government authority to collect private debt. A murmur moved through the gallery again. I asked calmly, what government authority do you believe is being used? She responded instantly. This court. That was the moment the misunderstanding became clear. Karen did not see the court as a neutral system. She saw it as an opponent, something trying to control her rather than resolve a dispute. That shift is critical. Because once someone sees the courtroom as an enemy, every ruling feels like persecution, even when it is simply evidence being evaluated. Thomas's attorney then presented something new, a series of approval emails from Karen. Each one more specific than the last. Approved. Looks good. Proceed with final phase. Karen didn't deny them immediately. She hesitated. Just long enough for everyone to notice. Then she said, those were sent under pressure. I asked, what pressure? She answered without blinking. The pressure of expectation. There was a brief silence. Even the bailiff shifted slightly, because that answer was not legal. It was emotional. And emotion does not replace documentation in court. Then Thomas's attorney submitted photographs of the completed project. The kitchen was modern, the flooring clean and professionally finished, the exterior wall repaired exactly as described. Karen looked at them and finally said something different. Not legal, not constitutional, just personal. He overcharged me. And for the first time, we were finally at the real issue, but Karen still hadn't accepted that. When Karen Blake said, he overcharged me, the courtroom finally shifted into the truth beneath all the noise. Not constitutional arguments, not procedural speeches, not selective interpretation of rights. Just a payment dispute, civil clear, and fully documented. Thomas Reed didn't react immediately. That's something I noticed about him throughout the entire hearing. He didn't chase every accusation. He didn't interrupt every distortion. He waited for the record to speak. That patience mattered. Karen, however, mistook his silence for weakness. "This is exactly what I mean," she said, turning back toward me. "Contractors take advantage of homeowners and then hide behind paperwork." I asked her, "Did you approve each stage of this work?" She responded instantly, "I approved expectations, not exploitation." That sentence lingered in the room for a moment because it sounded meaningful, but it had no legal structure behind it. Thomas's attorney then submitted the final set of messages. This time, they were longer conversations. Kerrigan had written things like, "This is better than I expected. I'm happy with the progress. You're doing great work." Each message contradicted her current claim. Karen stared at the screen. For the first time, her confidence slipped, not fully, but enough. She immediately said, "Those messages were manipulated." I asked, "By whom?" She hesitated, then replied, "By context." That was not an answer. That was avoidance wrapped in language. Thomas finally spoke again, softly. "Mom, you told me you would recommend me to your neighbors." Karen turned sharply. "I never said that." Thomas nodded toward the screen. "We have it right there." Silence followed, a heavier silence this time, because it was no longer about interpretation. It was about contradiction. Karen exhaled sharply, then did something unexpected. She reached for her printed pages again, but this time her hands moved faster, less controlled, more urgent, and she said, "The Constitution protects me from being forced into unfair financial agreements." I looked at her directly. "Mrs. Blake, you were not forced. You agreed repeatedly in writing and in payment." Her voice rose. "I was under pressure," I replied calmly. "Discomfort is not coercion." That line changed the energy in the room because it separated emotion from law. Karen stopped speaking for a brief moment, just long enough for the evidence to catch up again. Thomas's attorney then presented the final document, a signed completion certificate, signed by Karen herself. It stated, "Project completed to satisfaction." Karen stared at it, longer than anything else, and for the first time, she had no immediate response, no constitutional reference, no procedural objection, no accusation, just silence. And that silence told me more than everything she had said all morning. Silence in a courtroom is never empty, it is pressure. And Karen Blake was finally feeling it. She stared at the completion certificate as if it had changed its meaning simply by existing in front of her. But documents do not change under observation. They only reveal what was already true. Thomas Reed sat still, watching her carefully now. Not with anger, not with satisfaction. With the quiet patience of someone who has finally reached the end of being doubted, Karen broke first. "This is not what I signed," she said. It was softer than before, less confident, more defensive. I asked, "Are you claiming the signature is not yours?" She hesitated. That hesitation mattered more than a yes or no. Then she said, "I'm saying I didn't understand what I was signing." There it was, the shift. From denial of facts to reinterpretation of responsibility, Thomas's attorney immediately responded. "The document is signed, dated, and witnessed." Karen interrupted, "That doesn't mean I had informed consent." The gallery reacted slightly. Because now the argument had moved away from construction and into abstract reinterpretation of everything she had ever agreed to. I leaned forward. "Mrs. Blake, you received work updates, approved each phase, made payments during construction, and expressed satisfaction in writing." "What exactly was unclear?" she answered quickly. "The final cost structure." Thomas then submitted the original contract again. The cost breakdown was itemized, clear, step-by-step material costs. Labor costs, optional upgrades, final balance. Karen shook her head. I didn't agree to that interpretation. That word, interpretation, kept appearing because it allowed her to treat facts as flexible. But facts are not flexible in a courtroom. Then something changed in her behavior. She stopped addressing the contract entirely and turned back to me. "This court is biased," she said. Not loud this time, controlled, almost rehearsed. I asked, "On what basis?" She replied, "You are refusing to acknowledge constitutional protections." I looked at her carefully. "Mrs. Blake, the Constitution does not cancel voluntary financial obligations. That should have been the end of it." But Karen was past listening. She opened her binder again, fast, almost frantic now, and she said something that surprised even Thomas. "I am filing a formal objection to the legitimacy of this proceeding." Then she added, I do not recognize this court's authority over me. That sentence did not create legal effect, but it revealed something important. Karen was no longer trying to win the case. She was trying to invalidate the environment where she was losing it. That is a psychological turning point I've seen before. When people cannot win within the system, they attempt to declare the system invalid. Thomas's attorney leaned toward the clerk and quietly requested enforcement of judgment based on evidence already submitted. But before I could respond, Karen stood up again, and this time her voice carried something different. Not confidence, not anger, something closer to desperation. "If you rule against me," she said, "this will not stand." The room went still again because now everyone understood. This case was no longer about money. It was about control, and Karen was about to lose it completely. When Karen Blake said, "This will not stand," the courtroom didn't react the way she expected. No one looked threatened. No one looked convinced. They looked tired. Because by that point, everyone had seen enough evidence to understand the pattern. And patterns are hard to argue with. I reviewed the full record one final time, signed contract progress approvals, payment history, Wharton praise, completion certificate, every document pointed in the same direction. Thomas Reed completed the work. Karen Blake approved it repeatedly, and then she refused final payment. I delivered my ruling, judgment for the plaintiff, Thomas Reed. Full payment of the outstanding balance. Court costs included. Case closed. Karen immediately stood. "This is unconstitutional," she said again. But her voice was different now, less force, more collapse. I looked at her and said calmly, "This court has applied the law. The Constitution does not eliminate contractual responsibility." For the first time, she did not interrupt, not immediately. She looked around the room as if searching for support that wasn't there. But there was none, because the record had already spoken. Thomas lowered his head slightly, not in victory. In relief, the kind of relief that comes when you are finally believed after being questioned too many times. Karen gathered her papers slowly, no dramatic gestures, no speeches, no citations, just paper. As she turned to leave, I added one final observation for the record. Legal language does not replace evidence, and confidence does not replace obligation. She paused at the door, but did not respond, and then she left. The courtroom slowly returned to normal. But cases like that never fully leave memory because they are not really about contracts. They are about what happens when someone believes the law is something you can cite instead of something you must live by. Karen thought the Constitution was a shield against consequences, but in the end, Constitution did exactly what it was designed to do. It protected the agreement, not the avoidance of it. And that is why this case stayed with me. Not because she quoted the law, but because she misunderstood its purpose entirely. And in a courtroom, misunderstanding has a cost.